Welcome, everyone, to today's series from Berkeley Center for Law and Technology, our Expert Series webcast. We have a fascinating program today, and one that you won't find many places. You don't see these discussions as frequently as you should. Those of you that have seen programs before, my expertise is patent law. Patent litigators are not known for mediation, arbitration, or settling anything in a easy fashion. So this is probably a good learning experience for me, maybe a little bit of therapy for me. So we went and found a set of experts that I'm proud that we've worked with Winston Strawn several times, but the arbitration, International Arbitration and Dispute Group, we have not worked with, and found two great experts. So I'm going to introduce the moderator for our discussion today, Imad Khan. Imad is the Houston office of Winston Strawn, runs, well, I guess the Houston office and a major management role for the International Disputes Group there at Winston Strawn. So Imad, thank you for pulling this together and making this suggestion, and I look forward to learning from you, and I'll get out of the way and turn it over.
Great. Thank you, Wayne. And thank you to the center and the panelists, for agreeing to do this program. Let me start by just a few words about the relevance of the topic today. We live in a world with increasing relevance, of technology in our lives, increasing relevance of intellectual property issues, contract issues that deal with the technology industry in particular. And so we wanted to put together a panel to address this because, looking at some of the numbers that I had researched for this program, the tech industry, year after year, is increasingly contributing to the global economy and increasingly going up in numbers with respect to GDP growth, all within the US and also outside the US. And when I say tech industry, that includes, broadly speaking, broadcast and telecommunications, e-commerce, computer products, electronic products, computer design systems and related services, information services, data processing, and so much more. And so it's not surprising that because the global economy is increasingly reliant on the tech industry, so too we see disputes in this arena. And those disputes happen in domestic courts and national courts, but they also happen in ADR. They're mediated or they are arbitrated. Just to give you guys an idea, looking at some of the stats for how many cases in the tech industry are just arbitrated, I'll share two numbers with you just from two centers that are related. The AAA, which is the American Arbitration Association, published that just in 2023, they saw a 22% increase in technology disputes, and the value of claims ranked for them in the top 5 in terms of the largest amounts claimed at 458 million. ICDR, which is its international arm, had a similar stat, noting in 2023 that over 26% of their cases were related to the technology industry. And so given the prominence of this industry, we wanted to put together for you all and for the benefit of the audience here, an audience or panelists rather, that deal with these disputes, on a regular basis. So I'm going to turn it over to have my co-panelists introduce themselves. You'll note that we are a diverse group of people from different backgrounds. Some of us are IP specialists. Some of us sit as arbitrator. Some of us are running arbitration centers internationally and engaged in international dispute resolution day to day. So with that in mind, Danielle, can I have you introduce yourself, please?
Sure. Hello, everybody. I'm Danielle Williams. I'm a partner at Winston & Strawn. I am co-chair of our intellectual property group. I've spent several decades now working in intellectual property disputes, primarily in the district courts in the United States. But I frequently have the opportunity to talk about and evaluate arbitration provisions and various contracts.
Thanks, Danielle. Paul, over to you.
Hi, everybody. Thank you. My name is Paul Sills. I am an independent arbitrator and mediator, originally from New Zealand, but now full-time working in London. I was a barrister for 30 years in New Zealand, where IP disputes would sort of frequently come up in the commercial courts. And also now as an arbitrator, I have a particular interest and specialty in fintech end of the tech market, so the blockchain, smart contracts, and crypto disputes market, which is, we'll probably talk about today, sort of growing almost by the day. So very pleased to be here.
Thanks, Paul. Adriana.
Thanks, Imad. I'm really pleased to be part of today's webinar and to join the distinguished panel of experts. And a big thank you to Berkeley for having me. I'm Adriana Uson, and I head up the Americas office in New York of the Singapore International Arbitration Center, or SIAC. And from where I sit, both geographically and institutionally, I get to see how businesses, especially in the IP and tech space, are increasingly turning to arbitration to resolve cross-border disputes. And Imad just ran some numbers from the other institutions as well. So today, I'd like to share a few insights on how arbitration is evolving to meet the needs of companies dealing with IP and tech-related issues. So it's a pleasure to be here.
Thanks, Adriana. Before I go to the next topic, I should say, thanks to technology, we can also be in different parts of the world and put this program together with the help of Berkeley. So that's been great. I'm just going to quickly go over what we will discuss, and then we're going to dive right in. So the topics we're going to discuss include identifying types of contracts and commercial relationships in the tech industry that would be well suited to arbitration. That's going to be the first thing we touch. Then we're going to go on to some discussion about reasons why technology industry disputes should be arbitrated. You know, what are some of the pros and benefits that you get from arbitrating these disputes over litigation? Then we'll follow on to a discussion of a case scenario, just to put an example in front of you all regarding two very similar types of disputes, one which was litigated, one which was arbitrated, to see how some of those pros of arbitrating a dispute can come into play. And then we'll end with some succinct and brief recommendations on drafting effective arbitration clause so that you can have the benefit of this group as you're contemplating putting in an arbitration clause in your contracts. At the outset, I will note, it's not my perspective is, and I'd love to hear other people's opinions on this too as we go through this discussion, but my personal approach is not every IP or technology dispute, not even every dispute needs to be arbitrated, right? Arbitration is not perfect for every single type of dispute out there. However, it is very useful for certain types of disputes and certain types of commercial relationships among parties. And so what I hope that you all walk away with today is at least thinking about, for a given relationship, for a given contract, is arbitration the right option for you, as opposed to just defaulting to whatever it is that you generally may adopt. So with that in mind, let's turn to Danielle for a discussion of what types of contracts, Danielle, have you seen in your experience? What types of commercial relationships have you seen and that you see your tech clients engaging in, where you think that arbitration may be a useful option for the tech industry to consider?
Thanks, Imad. So I'm excited to kick us off with the first topic. So I would say, I think generally speaking, where I see the arbitration provisions the most, it's where there's a collaboration component, and that's across the spectrum of technology. So this is where maybe you're collaborating with a vendor to acquire technology. Maybe you're collaborating with someone that you're working to build or to build technology either for you or for the broader industry. And so when we've got the collaboration component, that's where I see the arbitration provisions having the best opportunity to be exercised. And here's what I think is driving that. Number one, when you're in that collaboration mode, you want to use the technology, you want to bring it out there. So if there is a dispute, you want the dispute resolved quickly. And there is an opportunity, and we'll talk about it later, through the arbitration provisions to increase the speed with which the dispute is resolved. Because if you want to use the technology, the dispute can be a hurdle, an obstacle, instead of just a speed bump or one of those roadway cushions, which is even lower than the speed bump. So I think the arbitration provision has the opportunity to let the dispute resolve more quickly. The other thing is, if you're working on technology with a partner, you may want different kinds of privacy, different kinds of confidentiality, and I think that drives collaboration partners to arbitration instead of taking the opportunity to go to the district courts, where so much is unpredictable about what is going to be disclosed or not disclosed to the public. And the third is the extent to which these parties have collaborated before, and their confidence and comfort level with arbitration will drive the inclusion of the provisions in their agreements. And I was thinking about, is there a particular area of technology where we see this more? And I don't think that there is. I think that it really is the parties and their mindset coming to it, what their goals are for the technology that is driving it. But we see it across technologies now, AI for sure, and then we're seeing it in digital assets. In preparation for this, I took a look at the World Intellectual Property Organization's stats. You know, they've got their arbitration and mediation center. And the other thing that they've got there is little case studies where you can go and see the different technology areas and the cases that have been addressed using the arbitration and mediation center. And I just wanted to share that the growth over the last 5 years for cases that have been referred to the arbitration and mediation center surprised me. And so in 2020, there were 182 cases referred. And in 2024, there were 858 cases referred to the Arbitration and Mediation Center for WIPO. And then when you break it down further into the industries that are taking advantage of that particular structure, we see everything from AI generated content ownership, collaboration contracts, as we talked about before, copyright, data privacy, information and communication technology, licensing agreements, service agreements, R&D and technology transfer, and then of course, you know, what I'm most familiar with, you know, patents, trade secrets, trademarks, and intellectual property infringement. So the variety of technology areas that are being presented, and then the growth in the use of the arbitration and mediation center is certainly interesting, and suggests that there is an increase in comfort level with arbitration. Sorry about that. The other thing I will say is the Unified Patent Court, relatively new court on the global landscape, released its annual report for 2024 earlier this year, and top on their list of things to get going is their arbitration and mediation center. And so on their list of goals for 2025 is to have that up and running and operational. So it'll be interesting to see what opportunities there are there for different companies and individuals in technology and how they're able to leverage arbitration there. So Imad, there are contracts that are more suited than others for sure, but what's exciting is that the sky's the limit, and that people seem to be thinking about it at the front end, to be in a position to exercise it, to leverage the provisions when the opportunity presents it. And ideally, it will give these folks who want to use the technology a speedier outcome to their dispute, so that everyone is in a position to advance their goals for the technology.
Danielle, what I find interesting and just even what you've seen in the stats, right, I think really reflects practice that we all see, which is the types of claims, right? So these are in the tech industry, it's not just sort of breach of contract type claims, but really it runs the gamut of the types of issues you see. And because you're in the tech industry, I'm glad you brought up that there's IP-based disputes and IP-based claims and defenses also coming into play. And that's something to think about, as you said, like sort of on the front end, because that's when you get a chance to, put in these dispute resolution clauses.
Yes, I couldn't agree with you more. And at the outset, when you're beginning these collaboration opportunities, everyone is very excited about what the potential is, and the potential runs the gamut, and being prepared for a dispute, I think, is something that we all benefit from. We're not sort of worried about how are we going to resolve the dispute. We've got the provision in there through the arbitration provision, and that should give or could give comfort to the collaborators, that however they proceed forward, they're going to be able to present this technology, whether they're using it for themselves or making it available to the world.
Danielle, one more question I have for you, and I'd love to also hear from Adriana and Paul on this one, is in terms of the disputes you've seen or the clients you're advising within this industry, do you see, and if so, like what's sort of the breakdown, if you can guess, contracts, relationships, commercial relationships, more in the domestic sphere, so that the client is, dealing with someone within their own jurisdiction, a U.S. client with a U.S. counterparty? And/or are you seeing also that you've got sort of a company from one country collaborating or entering into these relationships with another counterparty from a different jurisdiction altogether? Can you speak a little bit about that? Because I think sometimes the international aspect of transactions can play a role in your dispute resolution clause.
In my experience, it's been primarily domestic disputes with the opportunity to exercise the arbitration clause. I know from your experience, Imad, that yours have been multinational.
Yeah.
And so involve multinational companies with opportunities to hold the arbitration in different countries. And then, of course, we see that across the intellectual property work that we do, is that we see a lot that's domestic, and then we see probably a little bit, I would say, if I had to guess, I'm going to say 3/4 domestic, 1/4 international, and we may need to correct that at some point, but that would be my rough guess.
What, Adriana, Paul, what about you guys? Like in your experience, what type, is it more domestic transactions that are going to arbitration, or international, and even not even going to arbitration, but what are you seeing?
So from SIC, we're seeing more international disputes. So actually, we have administered cases involving IP and tech disputes over across 40 jurisdictions from Europe, Middle East, APAC, North America. And I think this is because really of the benefit of arbitration. So, where companies operate internationally, IP disputes often involve more than one jurisdiction. And the resolution of a dispute may require parallel litigation in courts in different countries, so which can lead to conflicting judgments. So what arbitration does is that it offers the possibility of pulling it all into a single forum by consolidating multiple parallel IP proceedings, which I think makes for more consistent outcomes and easier global settlements. So that's what we see at SIC.
Yes, and I would echo that. I think the international complexity of sort of cross-border transactions in this IP space is certainly growing. And the stats you talked about before, and the stats you look at, say, from WIPO, sort of endorse that certainly the volume of international disputes is on the increase. And that kind of goes hand in hand with, a lot more jurisdictions these days becoming interested in having, IP or tech centers or innovation hubs. There's a lot more collaboration going on. globally, like Adriana, I see a lot of that coming out of Singapore, out of the Middle East, where there are, now well-established innovation hubs, but they are not just working regionally, they're working globally. So the level of sort of joint venture and collaborations, going back to Danielle's point about, some of the traditional disputes that come into the sphere, certainly the volume has increased significantly over the last few years. And it's inevitable when you're dealing with startups and these big global collaborations that disputes or issues are going to arise. So, I think we are seeing a lot more of them heading towards arbitration and heading towards places like, the Singapore International Arbitration Centre for resolution.
No, and I'll just add, that's sort of been my experience, as Danielle said. I do mostly cross-border disputes, so I just by definition see a lot of it. But a lot of our clients have these tech disputes, the same one that have international disputes. And so, there's certainly opportunity as well in the domestic sphere, if that's where that's where the contract is being performed with two domestic parties, where I think some of the things you'll hear about why arbitration is, well suited for, many types of tech and IP disputes, you should keep in mind that, what we're talking about is not just international, but it can also play in the domestic sphere as well for domestic arbitrations. So with that in mind, I would like to move to Paul to sort of set the scene for us and talk about, what are some of the benefits of arbitrating an IP or a tech-based or tech industry dispute.
I want to start where Adriana was, and we were talking just about the international stuff before, the more sort of general points that apply to international or domestic. And very, very strongly in the sort of favor of arbitration, I think internationally, is this issue of enforceability. The ability through the New York Convention to be able to enforce your award globally with relative ease, in fact, far more ease than many, foreign judgments from foreign national courts. So that sort of strength of arbitration coming from the New York Convention is, I think, the real powerhouse internationally that brings a lot of the market into that sphere. And interestingly, not really the topic for today, but interestingly, I'm not sure whether, the New York Convention was very much a creature of the 1950s, and I'm not sure we would have the same success in getting it passed today with, 172 plus countries having signed up to it. So that is very much the cornerstone of what brings real strength to arbitration internationally. But of course, there's a lot more than that applies to domestic or international. And really, the way I describe it, it's a dispute resolution framework that really suits innovation and can work, I think, really well with innovation and with tech things and moving at pace. First and foremost, really one of the key issues is confidentiality. Of course, when you're dealing with tech and IP, and certainly at the cutting edge, you're often dealing with secrets, with patent issues, with product roadmaps, with the back end of language model algorithms and things. So they're really sort of, very top secret, very costly programs and things that people are, of course, are incredibly careful to protect. Now, of course, you can get a lot of those protections in court, but just that cornerstone of arbitration of having that confidentially, not just about the privacy around the fact that the dispute is taking place, which in itself might be an issue, but the confidential protections around the information and its disclosure, I think, are an incredibly strong advantage of arbitration in this space. Neutrality, sort of the neutrality of the service and neutrality of the process, I think, is important. It provides really a level playing field, and I guess here, particularly for cross-border disputes. So rather than struggling with sort of home court advantage in terms of national courts, you can select institutions, you can select arbitrators, you can select processes that sort of neutralize power imbalances or perhaps, public policy issues that might arise in one jurisdiction and don't arise in another. I think also a very important point. Control and customization, we talk about this a lot as arbitrators and in the arbitration community, and often it's a criticism of arbitration that there isn't enough customization, for the process to fit the dispute. But I see this happening a lot more, and we're going to touch upon this later. I think I see this happening a lot more throughout the institutions where we have, expedited procedures, we have emergency arbitration. Arbitrators are sort of increasingly encouraged to work with the parties to design a process that is fit for purpose. And of course, that's one of the huge advantages of arbitration, is that ability to do so. Whether it be the structure of the submissions, whether it be the volume or the lack of disclosure coming into it, there is a real opportunity there to say, for these parties, for this particular dispute, what is the best, the most efficient way to bring this to a resolution? There's an increased, I think, incentivization to settle when you're dealing with arbitration versus litigation. And that suggestion that the privacy of the process can foster pragmatism. So rather than that sort of litigation treadmill that we often find parties get on when they're in the public arena, arbitration as part of that sort of private dispute resolution process, albeit determinative, does encourage the parties to engage at a slightly different level. It helps preserve the relationship, and it helps the discussions, if I can put it simply, get more realistic and more commercial faster than often through the litigation process, where the parties are working closer with the tribunal, often working closer with each other to bring matters on, and say in an expedited fashion. And the fact that it's confidential and private can really encourage the parties to get pragmatic about what they are looking at trying to achieve. Procedural flexibility is really important, I think increasingly important for tech disputes. And picking up on Danielle's point, the breadth of tech disputes that we are seeing is certainly growing. There are many jurisdictions now, for example, that will look at the validity of a patent, even though it might just be as between those parties. And so having the procedural flexibility to bring in the right sort of experts, to look at experts maybe appointed by the tribunal as opposed to the parties, just really get down into what sort of evidence, what sort of detail is needed for that particular dispute, I think is very important. The courts, yes, there are technical courts that deal with, say, construction or patent disputes, etc. Not denying that, but that very inherent ability for the parties to take control of what they want to see, what they want to do in terms of the way that they want that particular procedure to run is really, really important. And back to your point, Imad, from earlier, I say all that recognizing, and I think it's important to put the caveat that, we're not talking about arbitration being a silver bullet for everything. There are issues, as we know, with arbitrability around the world and different approaches to that can cause some conflict. That idea of, one jurisdiction allowing a patent dispute to come in, or a trademark dispute even, or a copyright dispute, these things that have traditionally sat with the courts, and other jurisdictions perhaps not taking the same approach, is a realistic sort of caveat within the structure of arbitration that always needs to be looked at. But there is no question that the breadth of and the utility of arbitration as a dispute resolution mechanism for the space of innovation is definitely growing, and definitely favors it. The points that I've covered certainly favor a highly tailored process to deal with innovation at speed, which is really what, a large part of what we're seeing around the world in disputes at the moment, I think.
This is a rather rich topic, and as you were speaking, Paul, I have all these questions, to dive into with all these different benefits, and kind of help educate a little bit more on each of them. First of all, I'm glad you mentioned that the New York Convention now has 172 parties. I always check every year when I teach, and the number has increased in the last decade since I've been teaching, so I have to keep updating my PowerPoint slides for students. I think that the New York Convention, I could be corrected, I think it is the top 5 most ratified conventions in the history of international law. which is fascinating that this convention on enforcing international arbitral awards has the most widely accepted position, or at least one of the top 5. I think it could be number 1. But let me start with confidentiality, and please, everyone should chime in. One thing, Paul, I think we should address is certainly confidentiality is a benefit that is available to parties who are arbitrating, but confidentiality is not automatic, right? These arbitrations can be private, but not necessarily confidential. So can you talk a little bit about what that means, how to ensure that you actually get confidentiality protections? And if I can add one more element to it, how there might be different levels of confidentiality even within one arbitration. For example, highly protective orders and things along those lines that maybe you've seen and perhaps you've granted as an arbitrator in these disputes.
Yeah, and that's a really good question, because confidentiality in the sort of theoretical space of arbitration is one of the most talked about topics, and confidentiality shouldn't be assumed. And the best place to, of course, to ensure confidentiality, because arbitration is a contractual and consensual process, is to put it into your arbitration clause. And it pays not to rely upon either the ad hoc procedures or the institutional rules to protect you. If you're in front of SEAC, for example, then there's very strong confidentiality provisions. If you are in front of WIPO, even stronger confidentiality provisions that really recognize its specialty as an IP arbitration and mediation center. But if you're in front of the ICC, which would be quite common for big multi-party disputes, confidentiality has a very light touch within their rules, and the parties would need to reach agreement outside of the rules to ensure confidentiality. So the cornerstone place to put it is always going to be in your arbitration agreement or your arbitration clause in your commercial contract to ensure that. And yes, the layers of confidentiality. So there is an overriding banner of confidentiality for your arbitration. Well, of course, in an IP dispute, you would expect there to be parts of the evidence that are more confidential or more contentious or more valuable or more at risk than other parts. And so you would expect in many IP disputes for one party or the other to seek undertakings around confidentiality to really sort of put the issue fair and squarely on the table and not necessarily rely just on the blanket cover of, say, institutional rules, but seek specific preservation orders or confidentiality orders from the tribunal to ensure and to control how that information is going to be used. So whether even, for example, it would appear referenced in the final award or not, as an example, because of course, one of the traps parties sort of can sometimes not think about is when it comes to enforcement or when it comes to challenges of awards. Of course, that's the time when all of these issues can hit the public domain as the award that we've all worked so carefully to keep quiet ends up in front of a court for enforcement or a court for challenge. So yes, on a big dispute that has trade secrets or similar at its heart, I would expect specific orders around the treatment of the evidence.
Thanks, Paul. I want to push that to Danielle. Danielle, if you'd like to chime in on this, confidentiality in U.S. court litigation. Certainly there's levels that are available even in domestic litigation, but can you talk about what levels you could get?
There is confidentiality in district court litigation in the United States, and nearly all courts have a standing protective order that has different layers for source code, for outside counsel only, and then for just general confidential information. That's during the discovery phase. When you get to the trial phase, it will depend on what your judge's preferences are for sealing the courtroom and unsealing the courtroom. And for those of us who have been in jurisdictions where the courtroom really needs to be sealed and the judge is very interested in the public aspect, the public's entitlement to view litigation, it might be the cure for insomnia, but they're still interested in that, making it available to the public. And so you get, it can be a difficult issue to manage once you get out of discovery. The other thing is, if you are a third party invited to participate in discovery, again, your protections are in the discovery phase. They're not at the trial phase based on the order that's in place in court. And so it's not at what Paul described, where you've got the opportunity for this blanket effect from start to finish, depending on how you craft or customize your arbitration provision. But it is something that you've got to protect. You've got to protect the information at the beginning and all along the way, including through trial. And that is, it's not always easy to do, because it's not something that you just get to set. It's in consultation and with approval of the court.
Yeah, so certainly some confidentiality available, certainly also in litigation, but it's not the extent that you get, in arbitration, if you get the right clause or the right rules in place to protect. And even beyond, like in my experience, we've had cases where in a tech dispute, we have had highly confidential protective orders on top of the confidentiality agreement, such that it could really limit who sees that information, including business folks, right, that you don't want, or other scientists or people in development who you don't want certain information to be seen by, despite the fact that they may be witnesses in the arbitration or participating in one way or another in advising on the dispute. Another area that I'd like to pick on is, I think this is an important one, is party autonomy over picking arbitrators. So Paul, if I can go back to you on this one, can you speak a little bit about the value of picking your arbitrator in a dispute that's IP focused or tech industry focused even? So from a legal perspective, but also from an industry perspective.
Yeah, look, picking your arbitrator is such an interesting topic, and I think one that really comes home to roost when you're talking about the specifics of IP, because there's a lot of debate globally around, subject matter expertise, and I'll be honest, I sort of sit on the fence a lot on that until it comes to the high end of tech disputes, because I think this is really an area where you can save a couple of things. You can save an awful amount of time and cost and energy by being subject matter aware, and you can save the parties a lot of that end of the process. But also, I think with the increasing complexity of IP and innovation and the speed of change, it requires a certain degree of subject matter expertise to be fit for purpose for determining these types of disputes. So I think it's a real advantage in tech disputes. I think it's a real advantage for the institutions like SIAC and Hong Kong and others to have specialist panels, and recognizing that there are arbitrators within their reach that do specialize in some of the subject matter, because the time saving and I guess the quality of the determination that can come from having that subject matter understanding, whether it's expertise or sort of a really good working knowledge, I guess is up for debate. Where the caution comes in, I think, is if you write, say, the parameters of what you want your tribunal to look like in your arbitration clause, you can be over prescriptive, and you can end up actually limiting the available pool of people that can work with you. And often, if you do that to too greater a degree, you'll find that a lot of them are either too busy or too conflicted to actually be available. So you very much got to get that balance right, I think. And whether it's, having a tribunal of 3 and having one as a subject matter expert, one as a legal expert. I mean, I see that, and I've had a lot of experience in the last couple of years of working on tribunals that are mixed with, with really good practitioners, whether it be an infrastructure project or a tech project, and legal. And I think that balancing works really well, where you've got perhaps a chairperson who has that subject matter expertise and is supported by the others within a tribunal. So it's a huge advantage of arbitration, is getting to think carefully about who you want and why you want them. And so, it is a real advantage. It's one that I think perhaps parties don't spend enough time on at the outset of, say, a tech dispute, to think, well, if this becomes an issue, who are the right sort of people to sit on this to give a fair, reasonable, enforceable result, all those things that you want from arbitration?
I'll just chime in real
Yes.
quick, Imad. That is one of the most appealing parts of arbitration, is the opportunity to pick the right person to evaluate your dispute, or person or persons. And just hearing Paul talk about it just reinforces what a terrific opportunity it could be if arbitration is right for the technology and for the parties.
That's true. I'll add one more point of agreement with Paul here, which is, I am also of the view that you don't necessarily want to put some of these things in an arbitration clause up front, but definitely think about it very seriously after a dispute has arisen to see what type of arbitrator you may need, because sometimes arbitration clauses can be very confining in terms, if you put some of these requirements in there, I'm not sure it works well necessarily. Staying on this topic for a second, I'd love to hear from Adriana. From an institutional perspective, you're getting tech disputes, increasingly so, as you said. From a selecting of arbitrator perspective, when the Secretariat has to get involved, how are you all, sort of addressing this need of arbitrators for these types of disputes?
I think Paul mentioned this earlier. So increasingly, institutions like SIC create specialized pool of arbitrators. So that is a guide for the parties. If they're thinking about nominating an arbitrator, you can look up our website to see that there is that list for IP, IT arbitrators. We're trying to expand that pool and make it even more specific to, say, experts in SEP, standard essential patents, disputes, FRAND disputes, fintech panels, and just it is really an area where, like what Danielle and Paul said, benefits IP disputes specifically because of the very technical nature. So that's one way of dealing with it. Of course, we also allow parties to choose their own arbitrator, so they're not limited to our list. We like what Paul said, they can actually specify the qualifications of the arbitrator at the outset. But again, I think I agree, it shouldn't be over prescriptive, because it might cause some problems in terms of compliance later on, or just finding the right person. I remember I was asked, I think sometime back, to give like 5 names from the US that's an expert in, I think, blockchain, crypto. And then I gave 5 names, and then the party said, well, they're not experts. And so the question is, well, how do you define expertise? So they want someone with 20 years experience. When the tech, is in place, then that would be difficult. So don't be vague about, some of the qualifications as well. So yeah, that's something for myself.
If I could just add one thing on top of that excellent point, is when does expertise become too much? Because when are you at risk of your arbitrator having preconceived ideas and opinions and hardwired biases because they are an expert within that field and they have their view on your subject matter? So it is such a nuanced decision, I think, in terms of appointments.
And I guess something, Imad, sorry to just
go ahead.
add. Parties are always free, if it's not written in their contract, to inform the institution actually when the time is right, when we're asking the parties if there are any qualifications, and we usually take those into account. So you don't have to tie yourself at the contract drafting stage on these qualifications.
That's fair. One other topic before we move to the next segment here, I want to talk a little bit about arbitrability, because, as Paul mentioned, that's certainly something that parties need to be aware of, right, when picking which disputes to arbitrate, because not every jurisdiction across the world makes it arbitrable to have some of the more IP-related disputes that emanate from the tech industry actually be subject to arbitration, right? 50 years ago, it was unknown whether IP disputes could be arbitrated under US law. That's been clarified now. They can be. But Adriana, can I turn to you on sort of the importance of arbitrability, even more so in tech disputes because intellectual property issues come up more so?
Yeah, I think, Imad, it's precisely like you said, there are still some jurisdictions where IP disputes are not arbitrable. They think that that's part of public policy and belongs to the courts. So be very mindful when you're choosing seats of arbitration, which I think we'll come into in a bit, because, it may well be the case that your dispute cannot be arbitrated. But just to share, Singapore really led the way in 2019. Singapore amended its International Arbitration Act to make it clear that IP disputes, whether the IP issues is the main focus or just part of a larger dispute, are fully arbitrable. And what's also great about Singapore's approach is that it's broad and future-proof. So it covers everything from patents, trademarks, copyrights, and it leaves room for newer forms of IP as tech keeps evolving.
Yeah, that was very important development that made the news across the globe. Just to flag for folks in our audience too, like generally speaking, if you have a seat of arbitration or if you're going to enforce an arbitral award in the US, Canada, certainly China for some of those disputes, Hong Kong, Singapore, some of these jurisdictions, many of them will allow IP disputes to be arbitrated, but there's some nuances to be aware of. You need to think about if your sort of IP dispute is a copyright dispute, because that generally is arbitrable in most jurisdictions, though not all. When it comes to patent or trademark infringement, majority of the jurisdictions will allow that to be arbitrated. But when it comes to patent validity or trademark validity, there we see a little bit of divergence, with some countries like US, Canada, England, France, Singapore, Hong Kong, that'll permit validity issues to be arbitrated. But at the same time, there's jurisdictions like Germany and China that do not want validity issues to be arbitrated because, as Adriana put it, they see that more as a public policy concern that should be dealt with on the national stage versus in a private, confidential, international arbitral space. So something certainly to be mindful of there. Any other words on arbitrability or any of these sort of pros of arbitration before we move to the next topic?
Yeah, and even just on that last point about even in some of those jurisdictions or many of those jurisdictions where patent validity is arbitrable, it's only as between those two parties.
This is true.
And so it doesn't apply in that broader public policy sense to apply to the world at large. And so even there are restrictions that people need to be aware of, because that might suit the patent holder. Also, that's a strategic decision, I think, to look at in terms of when you're weighing up arbitration, is that might actually be a very good thing. But yeah, there are still those restrictions in place.
No, that brings up another point, Paul, about enforceability, right? Like it's not just about the seat of arbitration, but where are you going to go enforce it? So think about where the enforcement would occur, because you might have a seat of arbitration that allows for arbitrability of certain disputes, but where you need to actually go enforce that award may not. And so why arbitrate and go through this long process only to get an award that wouldn't be enforceable, even under the New York Convention, which has a public policy exception, and that's the public policy for certain jurisdictions.
Look, absolutely. And I think public policy is an area that not just in IP disputes, but certainly in tech disputes is going to increasingly be tested or challenged as national courts, perhaps with geopolitics and things, look more deeply into public policy when it comes to enforcement. So it's an area I think that that is going to get a lot of attention over the years to come from the enforcement courts.
Good deal. I'm going to move on to our next segment now. I'm going to start a discussion here, and people should chime in. Given sort of the pros that we've talked about, this group has been sort of thinking about case scenarios, that we have seen where we've seen disputes being litigated and arbitrated. And, we thought we might want to put a case in front of you to show how arbitration can, in fact, be more suitable to certain types of disputes. So let me put some facts before you all. It's a tale of two technology disputes. As a literature major, I couldn't run away from my literary background and referencing Dickens, so here we go. We have a US-based technology company that entered into two agreements related to separate technologies that it was developing. So one technology is in the healthcare space, and a separate technology, separate division of the same company has a cutting-edge technology in telecommunications. This US technology company decides to enter into a confidentiality agreement with two separate counterparties with the notion that if we share information, we might be able to enter into a joint development agreement of some sort, to advance the technology and, kind of bring it to market on a broader scale. Now, one of those agreements, the confidentiality agreement, had an international arbitration clause, so the disputes were to be referred to international arbitration. The other contract, however, didn't have a dispute resolution clause. It's a US company that was the counterparty for which was US. So the default rule, of course, is you're going to have to litigate anything that is disputed with respect to this confidentiality agreement. The two counterparties of the same US tech company actually bring separate but very similar claims, alleging in their own contexts that the US tech company has misappropriated the counterparty's technology, right? And all kinds of claims emanate from that. Their IP claims, their infringement claims, there's breach of contract claims, all kinds of stuff. And this is happening in both the arbitration in the contract that calls for arbitration, and the same types of claims are being litigated publicly in court for the contract that had no dispute resolution clause. One additional caveat here. Interestingly enough, we see that in the public litigation, as a stress point, the counterparty actually wrote to the US tech company's existing customers and told them to stop buying their product because there's a litigation about who actually owns this technology ongoing. That only happened in the public litigation. Ultimately, for the same US tech company, both of these disputes actually end up in settlement. But here's where I want to take you to show you how the process and the road to settlement was very different for the same company. So in litigation that we had, there was a settlement that occurred after about 10 years, and the settlement only occurred after the lower court entered into a decision and during the appeals phase of the US court litigation. By contrast, the dispute that was being arbitrated, we had a settlement that occurred within 2 years of the dispute being filed, and it happened before the hearing on the merits. So it never went all the way through and settlement was still achieved. Another difference is in the litigation, there were ancillary proceedings between the parties because the counterparty had now interfered with existing commercial relationships with customers. And so there were counterclaims and different litigations that were being initiated to stop that from happening and to claim damages for tortious interference with third parties. Unlike that case in the arbitration, where there were also customers that could have been informed that there's a dispute about the technology, none of that occurs because the arbitration was under confidential rules. That confidentiality was in the rules, it was in the procedural orders entered in, and there was even highly protective confidentiality rules that applied. So you don't see ancillary proceedings in the arbitral dispute. In the litigation, there were several preliminary objections, but it took the court about 8 years to decide them. It was very contentious litigation. Lots of discovery was happening, so it took the court some time to get to those decisions. Versus the arbitration, we had one preliminary application that the tribunal resolved in 2 months, so the process could move on to its next stage. On discovery, one of the benefits that we didn't get to talk about as much, but certainly is, at least in international arbitration, that you get tailored limited discovery, which is what we saw in the arbitral dispute. Documents only, and documents that are relevant and material to the outcome of the dispute. You don't get any and all documents related to any and all allegations. It has to be tailored to a particular claim and the relevance and materiality of the outcome of that claim. Versus in the litigation, unsurprisingly, in the US, you have extensive discovery that took so long before courts could even decide the preliminary issues, but there were documents, there were requests for admissions, interrogatories to do, depositions, and there were dozens of depositions that were happening both on the fact side and about a half a dozen on the expert side before you even went to trial. And the time and money spent, there's a lot of discussion of, is arbitration faster or cheaper than litigation? But let me put that aside for now. In this scenario, we saw actually more time and money spent because there was an appeals process, which is actually what resulted in the settlement. Whereas you got settlement in the arbitration with no time or money spent on appeal whatsoever. So at least on that level, there's no question that there's savings of time and moving processes along faster and less money spent. So similar, same company, two different technologies, arbitrating similar claims, and the results are different. So in my view, at least, I can see a situation where this litigation, which is a domestic case, could potentially have been arbitrated, or there could have been an arbitration clause that could effectively have been used to resolve these issues much quicker, probably much less costly because of the extensive discovery, and get parties back to business. I mean, ultimately, the parties settled and moved on in their own relationships. That could have been achieved, in my view, at least, a little bit faster if parties had thought about, do we need an arbitration clause here because of the issues we may face in a confidentiality agreement that didn't even turn into a joint development agreement just yet, which I would argue in a joint development agreement, it's even more necessary to think about these issues than, just a basic 3-pager confidentiality non-disclosure form that parties enter into before their scientists and developers can talk to each other. So something for you all to consider. Danielle, Adriana, Paul, any thoughts and comments are welcome here.
So this is Danielle. I'll add that the time and money spent on appeal and litigation, I mean, when you think it's done, whether you've got a summary judgment ruling or you've got a entry of a final judgment after a jury verdict, it's just getting started. And I think that your tale of two technology disputes has outlined that clear reality of the difference between litigation and arbitration succinctly.
Thanks, Dan.
Imad, yeah,
Yes.
I'll just jump in, Adriana here. So what jumps out from the fact pattern was the cost and the time spent. So significantly longer in litigation than in arbitration. And that's something, I think that's one of the biggest advantages of arbitration. It is the finality. For us at SIC, on average, for a sole arbitrator, we finish a case in less than a year. And for a 3-member arbitrator, it's a little bit over about 14 months. So that's something parties can consider. The other thing that I was thinking of too is that if this was a US litigation, I'm not sure whether the jury was involved. And so I do hear sometimes that for very technical disputes, it is surprising that this is put before a jury, whereas I assume in arbitration they have chosen an expert arbitrator rather to deal with the dispute. Sorry, Imad.
Yeah, no, actually no jury, was a bench trial, which is an interesting point. Okay, I'm cognizant of the time, so I want to move on to the next phase here, which is going to be our last phase. And it's about structuring arbitration clauses and the strategy to effectively resolve disputes. So Adriana, I'm going to turn to you to give us some insights and then have everyone chime in on some advice for our viewers here on what they should think about, elements to consider when drafting an arbitration clause, because perhaps we've convinced them now that they should arbitrate some of their tech disputes.
Thanks, Imad. So the starting point of arbitration is the arbitration agreement, because arbitration, it is based on consent. Parties can only use arbitration if they've agreed to it. So usually by including an arbitration clause in their contract, but sometimes even if the original contract doesn't have an arbitration agreement, parties can still agree to arbitrate after a dispute has already come up by entering into a submission agreement. Now, to make it easy for the parties, most arbitral institutions actually provide a recommended clause or a model clause. So these are tried and tested templates, usually available online, and copying these model clauses can prevent unnecessary headaches. So a good arbitration clause should always be clear, and complete. Otherwise, you risk creating what we call a pathological clause. So something so poorly worded, it actually causes more disputes instead of solving them. And so I'll quickly run through some essential components. So first, the clause should clearly state which kinds of disputes are covered. So will it include all disputes or only contract-related ones? Should anything be excluded? So it can be broad, covering any dispute connected with the agreement, or you can also narrow the scope to exclude issues that are better suited for litigation, or as we discussed earlier, might not be arbitrable in the chosen seat. The arbitration must also clearly say that parties agree to arbitrate. So avoid soft language like the dispute may be resolved by arbitration, and instead use the word shall be arbitrated, because courts might interpret that as optional rather than mandatory, which could, derail the process later. Also specify the seat, which is really important. The seat is a legal concept. It determines which procedural law applies and which courts have the supervisory power or authority to step in if needed. Seat is often confused with venue, which is the physical place where the hearing takes place, and these two things are different. So it is usually suggested to propose a seat that is neutral, arbitration friendly, a seat that is party to the New York Convention for the reasons that we discussed earlier, which is global enforceability. So some of the global favorites for seat are Singapore, London, Paris, or Geneva, unless a specific location benefits your company or your client. Now, arbitrator selection, which we've touched on earlier, you can also indicate that in your clause, a number of arbitrators. You can decide whether you want 1 or 3 arbitrators. 1 arbitrator is more cost efficient, of course, for smaller disputes, but 3 arbitrators offer more perspectives for complex cases. You can also choose the expertise, so that has been covered earlier. Specify clearly the language of arbitration to avoid later disputes. You may also want to specify not just what law governs the contract itself in your arbitration agreement, but also the governing law of the arbitration agreement itself, which can actually be different. And you might wonder why that matters. And this is because the arbitration agreement itself is treated as a separate contract, even if it's tucked inside the main contract. So it's advisable to spell out what law applies to it. So we have a recent case in Singapore. It's called Anupam versus Westbridge, which showed that this choice can shape major issues, again, like arbitrability of a dispute. Another important decision to make and to decide when you're drafting your clause is, do you want your arbitration to be administered by an institution, or do you want it ad hoc or self-managed arbitration? So what's the difference? I would often liken it to booking a guided tour for administered arbitration. So the institution handles the logistics, the rules, the deadlines, and even, steps in when something goes off track. So it's structured and it is predictable. Ad hoc arbitration is more like planning a DIY backpacking trip. So you and the other party will need to organize the schedule, handle disputes over process, and solve any hiccups along the way. So yes, it gives you freedom, but it requires more effort and mutual cooperation from the parties. Be sure also to specify the procedural rules that will apply. So when you name an arbitral institution like SIC, so some other institutions like LTIA, ICC, you're not just choosing the institution, you're also adopting and writing in the institution's rules. And these rules often come with helpful features. And I think Paul mentioned this earlier. So some rules, if you look at it, there is an emergency arbitrator provision for urgent interim relief. You have fast track or expedited procedures where you want a case to settle in or finish in 6 months. We have introduced at SIC an even shorter one for 3 months. We call it a streamlined procedure. So these are the things that you want to look at when you're thinking about which institution to include in your rules. Now, those are the essential elements. It sounds complicated, but again, it's really a simple copy-paste exercise of the model clause. I actually have it here, and I'll share it just quickly for our viewers to have an idea what it looks like. So that is the SIC model clause, and see we ran through most of the basic elements here, and that's something that you can just copy or build on. What else? I mean, the other things probably that you can add to the arbitration clause, and I think we've also discussed this, is confidentiality. Paul mentioned earlier that it is not inherent in arbitration for the proceedings to be confidential. So you may want to add that specifically to the clause. Imad?
If I can just add, Adriana, I do appreciate a detailed model clause like the SEAC one, right? Because it forces parties to really think about each of the different elements. First of all, it's an enforceable one, but it's a sort of take it or leave it or edit it as you will, but it kind of gives you here's the things to think about, right, as you're drafting. So that's very helpful. Thank you. One thing, and I'm going to open this up to Adriana, you or others, a quick word on tiered dispute resolution clauses. Let's go negotiate, let's go mediate before we arbitrate, and then let's go arbitrate, like the requirements, helpful, not helpful, does it come into play? I'd also love to hear from Paul about this, from his arbitrator experience, if these have been proven to be helpful or if they become more of a nuisance than anything else.
I'll start.
Yes. Sorry, Paul.
Sorry, Adriana, you go.
No, go ahead, Paul.
I'm going to say from my perspective, being both a commercial mediator and an arbitrator, they are really interesting. I think they have added great value to putting thought into the drafting of arbitration clauses and dispute resolution clauses. My only comment or / criticism on them is imposing an arbitrary time frame to mediate doesn't necessarily give us the best opportunity when it comes to the mediation of a dispute. I am much more in favor, it's harder to impose, but I'm much more in favor of requiring mediation, but allowing the timing to be somewhat up in the air, because when parties are ready to start negotiations is a very fluid thing, and often it is after the initial exchange of memorials or something where issues crystallize, reality crystallizes. So doing it at the front always doesn't necessarily get the best out of a multi-tiered dispute resolution clause.
Adriana, you had something else to add to this?
I mean, I echo what Paul said. I think I just wanted to also introduce, so there are also model clauses for step clauses. For instance, at SIC, we have what we call the ARB-Med-ARB clause. So you can start with arbitration, move it to mediation, go back to arbitration. So yes, we see some of these clauses being used and may be quite helpful in preserving relationships, and even, probably avoiding going through the entire exercise of arbitration. Maybe they end up in mediating and settling the dispute. And I guess one tip is just to make sure that it's very clear, the requirements before you need to move to the next step, because that's sometimes where, where the delay happens. So just arguing whether there has been suitable negotiations, whether the timeline has been met, like Paul mentioned.
I'll add from a litigator's perspective, when we have the opportunity to do the tiered approach, it is the absence of information that limits the benefit of mediation in advance of arbitration. So having the two-step approach is, in practice, if there's a component part where there's a significant exchange of information pertinent to the decision, it can help the process, and sometimes just getting to the heart of the matter. So proceeding with arbitration and then having the opportunity to go to mediation, like you were suggesting, Adriana, is helpful to a resolution earlier than through the complete process.
Thank you all. Okay, with time cognizant, I will ask one last question that I'll answer first, but for you all to consider. Let's go with Danielle, Adriana, and then Paul. What's the one key takeaway from this discussion, or one to do, or alternatively one not to do thing that you would like our viewers to think about? So my key takeaway is really, that as you're entering into contracts and relationship, just consider your dispute resolution clause seriously and consider whether arbitration can be a useful tool for the type of relationship and maybe the types of disputes that could arise from that relationship. Like, give it some thought, and if it's the right thing to do, then put in that arbitration clause in your contract and agreement. Danielle.
I would pull your second slide, Imad,
Yeah.
and take that with you when you are thinking about the arbitration clause and whether this particular relationship is one city or the other city, right? And just decide where you think it might go and where the opportunity is. And then I would also take Adriana's template clause and put it in the same PDF, staple it together, however you warehouse your information. So you've got that there and you can think about it as part of the contract drafting piece. Because what I do know, if it's not in the contract, we can't exercise the opportunity.
Adriana?
Yeah, so use the model clause and you won't have any problems. And I guess, I mean, I echo again what Imad and Daniel just said, just understanding the full menu of dispute resolution options that are available, looking at the various institutions, the rules that are available, preparing beforehand, anticipating what kinds of disputes and what procedural tools you might need when the dispute arises. And something that often comes to mind is what the Singapore Chief Justice Sundaresh Menon said, that ADR, which stands for alternative dispute resolution, may also mean appropriate dispute resolution. So choose what is appropriate for your dispute. Thank you.
I love that. I might be stealing and citing to both the Supreme Court Justice and Adriana when I use it next. Paul, last word.
Last word for me is when drafting or considering dispute resolution options or drafting arbitration clauses is to think of the clause like a circuit breaker. So that when you have a commercial relationship breakdown, how quickly can we use our dispute resolution provision to isolate that problem and resolve that problem? Because we are talking about an area of law and tech where speed, secrecy, and enforceability are particularly important. And so if you can't isolate the problem and resolve it quickly, then perhaps your forum is not right.
Thank you, Paul. Okay, with that, again, thank you to each and every one of you for participating and sharing your insights. Thank you, Wayne, for inviting us and to the Berkeley Center for Law and Technology as well.
Thank you for joining. And as I guess a retired trial lawyer who was always skeptical of, well, anything that didn't involve me and juries, what a wonderful conversation. And I love to see this moving forward to educate people like me from making bad decisions. So wonderful discussion and fascinating. And I look forward to hearing more from you through the year. Thank you.